So welcome everyone to tonight's constitutional conversation. It's first in a logistical note, which is that there will be a reception afterwards so that we can mingle and more people have a chance to get to know Judd after the talk. The reception will take place in the Manning Lounge, which is on the walkway, the second tier of the walkway inside. So everyone is invited. And now it's just such a pleasure to welcome Judd Campbell, the newest faculty member here at Stanford Law School, but hardly new. So he was a student here. He then clerked for Diane Sykes and Guido Calabresi.
Jose Cabranes.
I'm sorry?
Jose Cabranes.
Oh, I'm sorry. Jose Cabranes, I did forget. Judges, as you may know, are really outstanding judges from both sides of the aisle, and then came back as the executive director of the Constitutional Law Center. So, he was Morgan once upon a time. Morgan will be Judd once upon a time, and then has been teaching constitutional law at University of Richmond and has returned here to my great pleasure and to great acclaim. He'll be teaching Con Law 1 next quarter to first-year students. And tonight he's going to be talking about natural rights at the founding. This has been his principal area of interest for, a couple of years now. And you might have thought there's nothing new to say about this topic, which has been with us for so long. But I think you'll find that there is something new to say.
All right. All right, thanks so much. I'm going to split this up into three parts. I'm going to start by talking about the way that the founders thought about natural rights. This actually would apply into the 19th century as well. And in framing that discussion, I'm going to think generally about basic principles. So focusing not so much on the Constitution, the federal Constitution, but on the way the founders thought about rights more broadly. And then the second part of the talk, I'm going to shift over and talk about various parts of the federal Constitution and how we can see new things and better understand what the framers of the Constitution were up to, both the original Constitution, some of the provisions of the Bill of Rights, and also the 14th Amendment, if we appreciate the natural rights discourse that I'm going to talk about in part one. And then I'll briefly conclude with a few reflections on what this might mean for us today, how some of our confusions, doctrinally and otherwise, are stemming from a kind of lost sense of what came before. Not to say that we necessarily need to recover what came before in a jurisprudential sense, but we at least need to understand what the history was in order to make sense of our current moment. So let's start with how the founders thought about natural rights. The disclaimer that's really important to emphasize here, especially for the students, is it's not don't try this at home. It's actually fine to try this at home, but don't try it in court because judges are going to be very confused what you're talking about. And maybe don't try it here at SLS, although that would really test whether your professors read my tenure file when they decided to vote, because a lot of this stuff I'm talking about, although Michael's right, various pieces of it have been around for a while, they haven't really penetrated our legal discourse. We've tended to relegate discussions of natural rights and social contract theory, which I'll talk about quite a lot here, to philosophy departments. And so the reason you shouldn't be trying this in court is that for the most part, Supreme Court justices think that this is all irrelevant to their jobs. They start with the Constitution, then they go to structural principles, precedent, et cetera. And they don't really think back to first principles the way that the founders did. But at the founding, natural rights and social contract theory are really central to the way they thought about constitutional law. The basic gist of social contract theory is that we could better understand what the basic purposes and structure of government are by just imagining what would happen if we didn't have a government and why it would be the case that people would decide to form a political society in the first place. And this basically proceeds in three steps. Step one is we just imagine that we have a state of nature in which we have all of these disaggregated individuals. And this is not a very happy condition for a variety of reasons. And people will then decide to come together in step two and form a political society. And so step two is that we create a social contract. Sometimes this is called a social compact. And the basic idea is collectively forming, individuals decide collectively to form a political society. So the political society is now a corporate entity vested with the authority that individuals previously had in a state of nature. So I'll talk a little bit more about that in a second. And then finally, what we have is the creation through a constitution of a system of government. And the basic premise of this is that although in theory individuals could continue collectively to self-govern, in practice, at any scale, that's just not going to work. And so we need to deputize some people to act on our behalf rather than as a single entity, a single people, just doing everything ourselves. So we can't, at scale, do the sort of Massachusetts town hall model of governance. So through a constitution, we're going to create a system of government that's going to actually do the work for us. So let's then try to figure out how it is that what I've just laid out maps onto understandings of rights. And the basic idea here is that when we're in a state of nature, people have natural rights. And these are just capacities that individuals could exercise without the interference of a government. So this is the ability to speak, the ability to think, to pray, to have religious views, to eat, to walk. Virtually anything that you could do without a government is your natural right. And in a state of nature, your natural rights are circumscribed only by the limits of natural law, which is essentially the requirements of reason, justice, and morality. At the second stage, when people enter into a social contract, the founders think that they retain most or perhaps even all of their natural rights. And so we're collectively creating this social contract, but in doing so, preserving our natural rights. And then we can recognize a number of authorities that the government has with respect to those natural rights that will help better secure them. So here there are a couple really important takeaways. First is that the people in creating a social contract are delegating authority to the government to regulate those rights with two conditions. So the first condition is that the regulations have to be in promotion of the public good. So the point of creating a political society is to promote the interests of that society and the people within it, and we can only have authorization for the government, for the polity, to restrict those rights when doing so is in promotion of the interest of the society as a whole and of its members. So condition one here is promotion of the public good. Condition two is that the people themselves, because they have retained their rights in the social contract, have to be the ones who approve the restrictions of those rights. So what it means to retain the right is not to say that the polity, the people collectively, can't do anything with respect to the restrictions of that right, but rather it's to say the polity itself has to maintain control over that right. So there has to be promotion of the public good, and there has to be consent by the people to whatever restrictions the polity agrees to. So for example, even though it doesn't violate natural law to operate a public ferry, that's not an interference with other people's rights. It doesn't somehow violate the principles of reason, justice, or morality. The government can nonetheless come in here, the polity can come in and say operating a public ferry is no longer permissible unless you have a government license. And the reason the government has set things up that way is because they think that it's going to promote the public good if we actually allocate ferry rights. We're going to get more people invested in public transportation, et cetera, by setting up a licensing scheme. So the government is allowed to come in and restrict natural rights so long as doing so promotes the public good and so long as doing so is consistent with this principle of self-rule, that the people have control over their own natural rights. I should add, though, that this broad regulatory power that I'm talking about didn't apply to a narrow band of natural rights called inalienable natural rights. So there are some types of rights, freedom of conscience, freedom of thought are the two quintessential examples. Right to self-defense is often mentioned as another, where it's thought that transferring authority for the government to regulate those rights would not promote the public good. And so rather than having the government make individual decisions about legislation to restrict those rights, we're just going to categorically exclude power from the government to regulate those rights at all. For the most part, though, the government's allowed to regulate natural rights and promotion of the public good. Okay, so that's the first power that the government, that the polity has transferred from individuals in a social compact. The second power that the polity has applies even to that category of inalienable natural rights, which is a power to define the boundaries of natural rights. So even with respect to inalienable natural rights, there's a stopping point supplied by the law of nature as to where the boundary of that right exists, and the polity is the one that has authority in a state of political society to define where that right begins and ends. And then the third thing that's transferred from a state of nature to a state of political society is a power of enforcement. So rather than having a kind of form of vigilante justice where each individual is in charge of enforcing interference, enforcing their rights in cases of interference, what we're going to do is transfer to the collective political society the responsibility for stepping in and providing what is called the protection of law, the responsibility of the government to defend individual natural rights against private interference. So this is one of the things that's kind of interesting but confusing about earlier understandings of natural rights. They're often thought of as fundamental rights, but they operate against private actors just as much as they operate against the government. This is typically not how we think about fundamental rights today. We usually think of fundamental rights as operating against government and ordinary rights as operating against individuals. But at the founding, there's this really important way of thinking about rights grounded in social contract theory that stipulates that many rights are rights against individuals and not just rights against government. And indeed, the purpose of government is in large part to vindicate those rights against private interference. Another thing that's very different about the way that the founders thought about these rights is that the rights are, for the most part, retained in the social contract. So for us, we tend to talk about fundamental rights as something that exists because of their recognition in a constitution. And particularly today in the United States, because of their recognition in a written constitution. It's the enactment of the right through text that gives that right constitutional force. And we can see at the founding a different way of thinking, which is even prior to the formation of a system of government through the Constitution, people have already secured their fundamental rights in a social contract. Another aspect of this that's very different at the founding is that natural rights as I've mentioned, are regulable in promotion of the public good. And so today we tend to talk about constitutional rights as things that operate as trumps against legislation that's otherwise trying to advance the public good. What it means to have a right, at least a fundamental or constitutional right, is that the government can't come in and interfere with that sphere of liberty or sphere of property rights simply because it has some claim to the public good. And although there are exceptions, I want to come back to that in a second, we've already talked about the inalienable natural rights category. For the most part, the founders thought that rights, especially natural rights, are regulable in promotion of the public good. And then because of that, we have a kind of final contrast to draw between the way that we think about rights and the way that the founders think about rights, which is because rights are generally regulable in promotion of the public good, and because it's the responsibility of the people themselves to determine what regulations are appropriate and which aren't, it was up to representative institutions like legislatures and juries to decide how to restrict retained natural rights. And it's not up to judges to come in and say which restrictions of retained natural rights are appropriate or inappropriate. Now, I do want to mention that there is an understanding of rights at the founding coupled sometimes with the idea of retained natural rights that did supply more limited, more defined and limiting restraints on governmental power. I've already mentioned the idea of inalienable natural rights, but there's also an idea at the founding that customary law could supply fundamental rights that were defined in terms of things the government could do or couldn't do, and that customary law would operate essentially like we think of as constitutional law, supplying determinate limits on governmental power, things that constrained ordinary legislative authority. So this is stuff like the rule against prior restraints, the principle that the government can't come in and require you to go to a licensor before you publish something, or the right to confront witnesses in cases against you, a right that is recognized in the 17th century that provides you as a witness in a criminal case an opportunity to actually question the people who have accused you of a crime. Or the right to habeas corpus, or any other number of rights that many of which are mentioned in the Bill of Rights provide you quintessentially with criminal procedure rights, but also potentially civil procedure rights and other things that are grounded in customary law. So we have a general principle that the government can restrict rights in promotion of the public good, coupled with the idea that there are limits on the government's regulatory power, some of which are grounded in natural rights discourse, some of which are grounded in customary law. So now we can think about just a couple of puzzles. One of those puzzles is, what's the point of retaining natural rights if those rights aren't judicially enforceable limits on governmental authority? So for us, this is just a really weird way of thinking. We have these retained natural rights, and yet the rights can come in and be limited by the government for reasons that we ordinarily wouldn't allow rights to be limited. What's going on here? And the basic answer is that natural rights discourse is just serving a different function in the 17th and 18th centuries. So rather than being preoccupied with our debates about what the constitutional limits of governmental power are, natural rights discourse emerges, particularly in the late 17th century, and then in the American case, becomes especially prominent in the 1770s during the struggle for independence because of a totally different set of concerns. So the concerns that are animating natural rights discourse in England in the late 17th century are concerns about the grounding of governmental power and the structure of governmental authority. And these are debates about divine right versus popular self-governance. So does the king have authority from God to govern, or instead, do we need to have some popular account of governmental authority, which would then lead to, rather than royal authority in the first instance, an account of authority that stems from the people? And this is essentially the debate that's taking place in the late 17th century. It's the debate that John Locke is entering into in defense of, among other things, parliamentary authority. And then in the 1770s, Americans who are defending independence and asserting natural rights are not asserting determinate limits on governmental power. They're not saying England can't tax us because taxes are illegitimate. Rather, they're saying we have a right of self-governance because of our retention of natural rights. So because we have retained our right to liberty and property, we cannot be subject to restrictions of those rights by a foreign entity in which we have no representation. So the point of asserting natural rights here, it's really important at the time, but the point of asserting natural rights is not to try to define legally determinate limits on governmental power. It's rather to try to make claims about the necessary structure of governmental authority, including the fundamentality of self-rule. All right, so the first puzzle here we can think about in terms of the structure of rights discourse just serving a different function. And then the second puzzle that I want to focus on is if we're thinking about rights in this way, mostly focused on the structure of government rather than on limits on governmental power, why would we enumerate rights in a constitution? So, like, what's the point of doing that if the rights themselves are simply operating as structural principles rather than as more legally determinate limits? And I'll say just a couple things here. This is related to a paper I'm working on at the moment. One of the reasons why you might enumerate rights is to reaffirm basic principles of governance that you want to ensure that each generation learns. And because people are ultimately responsible for electing officials and have this responsibility of self-rule, we want to ensure that people are aware of the basic first principles of governance, including the notion that they have natural rights. And so that's one of the leading justifications, among other things, for Madison's introduction of the Bill of Rights in 1789. It's also important to recognize, though, that enumerated rights sometimes were mentioning more determinate limits on governmental power. Sometimes those limits could actually come from their enumeration, which is to say you might have basic fundamental rights that are listed in a social, that are thought to be retained in a social contract, but over time we might come to think, hey, it'd be a good idea to add a new principle to the constellation of fundamental rights, and we might do so through a constitution. So the framers actually do this. Article 6 mentions a ban on religious test oaths. This is not a principle that stems from natural rights discourse. It's not a principle that comes from the customary constitution. Test oaths were actually quite frequent at the state level in the 1780s, and yet it's a principle the founders think it'd be important to create. And so constitutional text can be a way of creating new limits on governmental power. And then finally, we might want to add or enumerate rights to a constitution, even if they already exist in an earlier social contract, when the enumeration of those rights would facilitate their enforcement. So having an enumerated right against prior restraints, even if the right against prior restraints already exists, already is thought to be fundamental, it might have a precarious status, because in the 1780s, judicial review is very contested. judges who had exercised judicial review had either been impeached or faced a push for impeachment. And so enumerating rights might be one strategy for emboldening judges to do something that they were thought to already have a responsibility to do. And so there are a variety of different reasons why we might want to enumerate rights, even though many of those rights were thought to be already retained in a social contract. I want to make one final point before turning to the Constitution itself, and that is that most of these rights were thought to be grounded in general law. So it's a law that's common across state lines, even though it's not coming from the federal Constitution. It's not federal law as such. It's a law that that cuts across state lines. Each individual within every state has the same basic fundamental rights that they had as British citizens. And so the thinking goes, there are these common rights that the citizens of Virginia, citizens of North Carolina, et cetera, all share. So this kind of basic set of rights that are recognized in a social contract, the thinking went, would be more or less the same across state lines, even though states might regulate those rights in different ways under local law. So that'll return to importance here in a second. Okay, so this is a lot to cover, but hopefully in shifting to part two, when we talk about different parts of the Constitution, some of the kind of central lessons of this way of thinking will start to seep in. And I want to talk about a couple different clauses that I think we can better understand if we have this view of rights that I talked about in part one. The first that I want to mention is the First Amendment Speech and Press Clause, or clauses, which say, quote, Congress shall make no law abridging the freedom of speech or of the press. And there are two things that are really puzzling about this. One of the things that's often puzzling to scholars about this clause is that the people who frame it in the first Congress say absolutely nothing about what the freedom of speech or of the press entails. So this would be very odd if the first Congress were creating a new right, because they said nothing about what they were creating. And so I think the kind of way of appreciating what they're up to is not to imagine them creating a new right. They're not writing a new provision like they did in Article 6 of the Constitution, the Testos Clause, recognizing a new principle of governance. Rather, what they're doing is just picking up an existing principle, something that's thought to be already secured under principles of natural rights or customary law, and making sure that that principle is reaffirmed in the Constitution. And the text itself actually suggests this. The reference to abridging suggests that there's some right that already exists, and the restriction is against abridging that already extant right. The second puzzle in the First Amendment that often confuses people is the first word, which says Congress, which then leads to the very frequent law school hypothetical. What if the president were to restrict your speech, or what if some federal judge comes in and restricts your speech? Do we read the First Amendment by referencing Congress as saying that essentially other actors in the government can do whatever they want? And from a historical standpoint, this strikes me as kind of silly, mostly because the right itself is not created by the text. And so although the text is recognizing a limit on congressional authority, it's not asserting that the right only operates against Congress. And in fact, as we saw before, the right operates against a whole range of actors, including state governments and private individuals. And so it makes perfect sense to think that your right of freedom of speech would apply not just to Congress, the entity singled out in the First Amendment, but apply more broadly to other institutional and individual actors. The next constitutional provision I'll mention is the Ninth Amendment. This is also one that's famously contested and confusing. The Ninth Amendment says, quote, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." And from a legal standpoint, this one's basically ignored now, as mentioned in Justice Goldberg concurring opinion in Griswold. But for the most part, we just don't understand what it means. Robert Bork famously calls this one an ink blot. I just want to say, from the standpoint of the 18th century, this is a perfectly sensible provision. Basically, it's recognizing that there exist certain rights apart from their enumeration, and the fact that rights are enumerated or not does not in any way affect their existence or fundamentality. So the basic premise of the Ninth Amendment is exactly what I'm talking about, the retention of rights in a social contract, rather than the sort of modern notion that our rights come from their enumeration in the Constitution. Let's then turn to a little bit trickier provision, one that I'm sure you guys are always thinking about, the Privileges and Immunities Clause of Article 4. For those of you who don't have your pocket Constitution handy, this one says, quote, "The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states." The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Now, unlike the Ninth Amendment, this one actually does have some bite today. Basically, it's read as a non-discrimination rule. So if states grant rights to their own citizens, they have to extend those rights to the citizens of other states. This clause doesn't limit how states define those rights. States get to create whatever rights they want, but when they create those rights, they have to apply the rights to the citizens of other states. Except for that some rights, for kind of puzzling and unexplained reasons, don't apply to the citizens of other states, like voting rights or fishing rights. And so we have a hard time understanding what's going on here, why we would distinguish one set of rights from another. But this clause makes a lot more sense from the perspective of social contractarian rights that I've laid out. The premise of the clause is that the citizens of every state have a common set of rights. So that's the basic idea of general fundamental rights, common across this various states. And then the clause is doing two things. So the first thing that the clause clearly does is that it requires other states to recognize those rights when citizens of other states enter those states. The second thing that the clause more arguably does, but that early case law established, is that when states regulate those rights, they have to apply equal equivalent regulations to out-of-staters. So states have to give out-of-state citizens property rights, and states have to apply equal rules with respect to those property rights when out-of-state citizens want to register property, sue for some violation of their property rights, et cetera. So it operates as an equality principle, a non-discrimination rule, much like the modern case law would tell us, but it's premised on the idea that there exists these pre-constitutional social contractarian rights that are common to the citizens of every state. I want to come back to that idea in just a minute in relation to the Privileges or Immunities Clause of the 14th Amendment. But before I do, I just want to mention one clause that's missing from the federal Constitution that's also often seen as puzzling, and that is an equal protection clause that applies to the federal government. We don't have one of those, and very puzzlingly, the Supreme Court has told us in a famous 1954 decision called Bowling versus Sharp that there actually is one of those that's hidden non-explicitly in the Due Process Clause of the Fifth Amendment. So we have an equal protection clause against the federal that applies to the federal government. It's just not specifically mentioned. It's hidden within the Due Process Clause of the Fifth Amendment. This is kind of gibberish. This doesn't really make much sense. But the basic notion that the federal government is required to recognize an equality of citizenship is fundamental at the founding. Nobody would have thought that's the sort of thing that needs to be mentioned. And so a basic idea of equality of citizenship for the founders would not have come from the Constitution. It's implicit in the very idea that you are creating a political society in the first place where individuals come together equally to become citizens. And so this just reflects a very different way of thinking about the role of the written Constitution in a system of fundamental law. We don't, at the founding, need to be thinking about everything as coming from the text of the Constitution. And along those lines, I want to just conclude here in part 2 of the talk with a brief discussion of the privileges or immunities clause of the 14th Amendment. So this is the provision that says that no state shall abridge the privileges or immunities, shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. This is talk about founding era natural rights, so I'll just skip over this pretty quickly, but say the premise of this clause is the same as the premise of the privileges and immunities clause of Article 4, which is that the clause is not creating fundamental rights. It's recognizing that fundamental rights already exist, already limit governmental power at the state level. And what it's doing is providing a federal hook for the enforcement of those rights by the federal government when those rights, if abridged by states, otherwise would not have been enforceable by the federal government. So prior to the 14th Amendment, Republicans, John Bingham, the drafter of the 14th Amendment, being among them, insist that states are required to recognize basic rights of citizenship. And this is the premise of the Civil Rights Act of 1866, which most Republicans sign on to prior to the enactment of the 14th Amendment. They think that these rights already exist, already limit what states are legitimately authorized to do. Bingham questions whether the federal government has authority to enforce those rights, even though they already exist, because he thinks the original Constitution leaves the enforcement of those rights to the state governments, state institutions, including state courts. And what is needed is a federal constitutional provision to make those rights, rights that already exist and are grounded in general law, enforceable at the federal level, enforceable by federal courts and by Congress. And so we add the 14th Amendment to the picture, making rights that already exist now enforceable at the federal level in ways that wouldn't have been true before. So where does that then leave us today? Well, what happens between the passage of the 14th Amendment and today is a radical shift in the way that we think about the grounding of rights. We, during the early 20th century, legal realists start to critique the idea both that there is a common body of customary law that exists out in the ether, that judges can access, that they identify without actively shaping or creating, and therefore critique the idea of general law that underpins the earlier understanding that there are fundamental positive rights that every state is required to recognize. And so there's this attack on the idea of general law that penetrates legal consciousness. It's recognized most famously by Justice Holmes in the dissent in the taxi cab case, picked up then in the Erie Railroad versus Tompkins case, and basically has now penetrated our legal culture so that we think today there is state common law and there is federal constitutional law. And these are different bodies of law. There is no body of law that exists in the ether that judges are accessing without actively shaping. And without this notion of a kind of general body of law that cuts across state lines that judges can access without shaping, we basically lack the infrastructure to be thinking about rights in the same way as both the framers of the original Constitution and the drafters of the 14th Amendment thought. And at the same time, we lose the idea of natural rights. The concept of natural rights is subject to withering critique for reasons that have very little to do with what we've been talking about here. For the most part, fights over natural rights have more to do with progressive critiques against the kind of perceived naturalness of property rights and liberty rights. And so they're critiqued by progressive scholars, by eventually progressive judges. And the basic takeaway is your rights are not coming from nature. Your rights are the product of human decision-making. That human decision-making needs to be purposeful. It needs to be directed towards the ends of government. And we should be thinking about ways that judges and other actors within the system actively shape the way that we perceive rights. And so this is a kind of critique of a notion of rights as naturally occurring types rather than as deeply social phenomenon. And over time, we come to embrace the idea that our rights are coming from the Constitution itself. The discourse shifts in really important, although subtle ways, from the idea that the 14th Amendment and other constitutional provisions secured certain rights towards a discourse about the rights that the 14th Amendment and other constitutional provisions created. We now talk about rights as 14th Amendment rights or First Amendment rights rather than as rights that the Constitution recognizes and secures. And so we come to think that the rights themselves are the product of constitutional enactment rather than a reflection of a kind of pre-political state of nature and then an initial agreement exiting a state of nature through a social contract in which we would recognize rights, grounding their fundamentality in something other than constitutional text and popular enactment. So I'll stop there and open things up if folks have questions or comments. Thanks so much.
I was going to prime the pump, if that's
Yeah, good.
all right. In your understanding, is the content of the natural rights stable over time? And that's related to this really interesting question that the Supreme Court hints at and never answers, which is if and when the 14th Amendment incorporates, is the term they use, the Bill of Rights as applied to the states, is it the same, and is there a change? Let's take the First Amendment. Is it the same First Amendment that's being incorporated, or is it changing over time?
Right. I think that the way that the current debate is framed about the time question is misconceived. So because the rights are not created in 1791 and are not created in 1868, the provisions in 1791, the First Amendment, and the provisions in 1768, the Privileges and Immunities Clause, are merely referring to another body of law, not constitutionalizing that body of law, not fixing that body of law in stone. Really, the way we should think about the rights is not as being time-bound, not as being constitutionally embalmed in 1791 or in 1868. Now that then raises the question, well, what do we do about changing perceptions of what those rights entail. And here, the two things are worth mentioning. So the first is that for the most part, natural rights are underdeterminate. And that's going to allow us to escape a lot of the tricky time-bound questions that we might otherwise worry about. Because for the most part, it's up to the people themselves to make decisions through legislative judgment about exactly what the proper regulations of those rights are or aren't. And so this is a way of thinking that would make us less preoccupied with like what did people think at a particular time, and it's focused more on the institutional authority question. Who is it that properly has authority within our political system to make decisions about how we should restrict liberty, how we should restrict property, et cetera. The second point that I'll make is, even with respect to those more determinate aspects of natural liberty that restrict governmental power, the idea, for instance, that there's a right to self-defense or that there's a right of freedom of conscience, it might well be the case that in some theoretical sense, the right doesn't change. It's out there, it's natural, and therefore incapable of change over time. And yet our understanding of what that right entails might change over time. And this is generally the way that the founders and people into the 19th century thought about common law, that in a sense, the common law was the same as it always had been. It was animated by certain unchanging principles, and yet our understanding of the particulars might develop over time. As we learn more things, we can come to see things that have been stable all along in new ways. So, to help you guys out, think about some scientific phenomenon that you would agree doesn't change over time, like how it is that we experience certain diseases and what it is that causes those diseases. Presumably, it has been more or less the same across time, and yet our understanding of those things has changed. And so this is, in general, the way that people at the founding and up through the 1860s think about the concept of legal change. There's a notion of stasis, but there's also this appreciation for customary development over time. And in that way, the idea of protection for natural rights and customary law start to bleed into each other. There's a recognition that through custom we can come to see certain things that prior generations didn't perceive would be violative of our fundamental rights as actually violations of fundamental rights. Importantly, though, it is popular decision-making, political contests in the 17th and 18th centuries that are at the vanguard of that process of the development of customary law, rather than a kind of purposeful judicial methodology that the Warren Court embraces, especially in the 1960s. Thanks.
I wanted to ask a question about, well, it's a two-parter. But so I understand your explanation for, it's not confusing that the First Amendment would just call out Congress, because that doesn't mean that it doesn't apply against all these other actors. But I guess I am curious, why though? Why call out Congress in that amendment specifically, whereas so many of the others, it's very passive voice, shall not be infringed, shall not be violated.
Right.
Especially since, according to you, the legislature is who can probably regulate it. So I guess I'm just still curious what you think about why call out Congress. And then also, again, just about the writtenness, all of this usage of shall not be infringed, shall not be violated, shall not be abridged. Is that, how should we think of that? Are they still just natural rights that are subject to regulation, or are they doing something to elevate them more to Trump's?
Yeah, thanks. So on the first question, there's a kind of simple genealogical answer, which is probably the right answer, and then there's a kind of interesting speculative theoretical answer. So I'll provide both of them just for fun. The simple genealogical answer is Congress is inserted in an initial draft, in revision of an initial draft of the Establishment Clause based on a concern that the original Establishment Clause might have disabled states from enforcing church bylaws and things like that in ordinary contract disputes. So they add Congress to ensure that it's not going to disable the enforcement in state courts of church bylaws. And then they combine the Establishment Clause with other provisions, including free exercise and the speech and press clauses, and just leave the wording as Congress shall not. And so it's probably not a deliberative choice with respect to speech and press rights that they singled out Congress. It's just a happenstance of this kind of particular genealogy of the drafting history. But I do think that the point I was making in the talk helps us account for why they wouldn't have been concerned about that drafting language. Right? So they add Congress, and then somebody might have thought, had they been educated by a law school in 2023, hey, why are we singling out Congress? This is going to allow the president to do whatever the president wants with respect to speech and press freedoms. At the time, that's not going to be as much of a concern because you wouldn't have thought at the time that your speech and press freedoms are coming from the First Amendment. And so the kind of background understanding of rights helps us account for the kind of lack of a fight over that. The more theoretically sophisticated but totally speculative answer is that recognizing a natural right might have suggested governmental authority to protect that natural right in a way that was inconsistent with the basic structure of the federal Constitution. So if you recognize a natural right, like a right to religious freedom or a right to speech and press freedoms, it might be inferred that the recognition of that natural right would not just mean the government can't restrict it, but that the government has a responsibility to protect it. And so it would be odd for the founders to mention a natural right simply as a natural right in the federal Constitution, which was creating a system of government that it was thought at the time was not designed to protect natural rights against third-party infringement. So the basic point of the Bill of Rights is to restrain the federal government's interference with certain rights, but not to enable the federal government to protect those rights against third-party interference. And notice that the 14th Amendment has the very same structure. The 14th Amendment is recognizing a disability on state power rather than recognizing a right as such that the federal government would then have the authority to enforce not only against state abridgment, but also against private interference. And there's contest, of course, over the scope of that principle in cases like Crookshank involving private violence. But this is kind of more theoretically interesting possibility, maybe not exactly what people are thinking at the time. So the second question. Yeah, so I do think that by the time we get to the late 1790s, there's a discourse that's emerged among the Federalist judges that came to link, that began to link three things: writtenness, legal determinacy, and judicial enforcement. We see this most importantly in Justice Iredell's opinion in Calder versus Bull, which basically says, insofar as we're dealing with an underdeterminate, not textually specified right, we shouldn't get involved as judges. This is a pushback against Justice Chase's suggestion in that case that judges might enforce principles of social contract theory in cases that violated the basic principles of natural justice. And so Iredell is pushing back against that. I think in doing so, he's suggesting that the enumeration of a right might be coupled with a sense of the right's legal determinacy and judicial enforcement. I think that that way of thinking presupposes that legal determinacy is necessary in order for judicial enforcement, and that part of it I think is often overlooked. So typically today, we see an enumerated rights provision and skip straight ahead to judicial enforcement. And I think the way Iredell's thinking about this issue in Calder versus Bull, there's a kind of missing step in the progression, which is that enumeration and legal determinacy are what lead to judicial review. It's not that judges, by having an underdeterminate textual provision, freedom of speech, let's say, are therefore empowered to start creating a whole body of law governing how the government's able to regulate freedom of speech. Rather, the way he's thinking about it is, by enumerating a particular right, we are providing a sense of legal determinacy that otherwise didn't exist. Query whether that's actually true. I think that it's a very debatable assertion, but it's the kind of assertion that you increasingly see in Federalist discourse in the late 1790s. Thanks.
Hi, my name is Megan. I'm an undergrad here, currently applying to law school, so I just wanted to thank you. You've given me a glimpse of what it could be like in law school, and it's reaffirmed my decision.
Good.
So thanks for coming to speak. But I kind of just had a question on how you create those like demarcations of like natural rights. Like you spoke a bit about how jurors, not judges, are responsible for like finding where natural rights end and begin and creating that sphere of liberty. So I was just wondering, like, could you give more specifics as to how we determine natural rights and like what entities are responsible for doing that?
Yeah, great. So one of the things that's really difficult for us to appreciate now is that they thought about this process as being quasi-interpretive. So in their view, it isn't like for us, when we hear a term like the public good, our eyes immediately roll to the back of our heads. We think about politics essentially as just a fight amongst different political factions, that there is no such thing out there as the public good, and that essentially what we're engaged in politics is just a struggle for power. And so you might imagine that struggle playing out in a jury room. You might imagine that struggle playing out in the halls of a legislature. But in any event, it's just politics all the way down. There's certainly plenty of cynicism at the founding about politics, but there is a sense that dispassionate legislatures can rise above that kind of narrow factionalism and search for something that the founders thought was real, was out there to be found, called the interests of the political society, or called the boundaries supplied by natural law. They didn't think that these things were immediately accessible in the same way that say, biblical text was immediately accessible. You can just look at it. It's there for examination, but they did think it was out there, that it was real, and that through a rational process, we could come to better understand what it required. And so there's a kind of interpretive dimension to this. At the same time, they recognize that it's underdeterminate enough that it really is important for the political society itself to maintain control over the decisions, both as to what the boundaries of natural law are and what the requirements of the public good are. And so because this is the sort of thing where we don't have a kind of neat methodology for identifying it, we have to provide an opportunity for the people themselves through self-rule to make these decisions. Quintessentially, people are thinking about the public good in particular more in terms of what it isn't than in terms of what it is. And so the kind of quintessential example of something that isn't in promotion of the public good is an effort by legislatures to entrench their own self-interests or to entrench the interests of a narrow segment of the population rather than promoting the interests of the people as a whole. This becomes a really important framing device for Republicans during the 1860s who acknowledge that there's a lot of ambiguity in what the public good requires, what reasonable regulations of rights might entail or might not entail, but who are adamant that simply excluding certain people from the enjoyment of civil rights or discriminating in their enjoyment of civil rights on the basis of race is not in promotion of the public good. So again, it's a kind of, there's a range of space in which legislatures can regulate, but a recognition that there are certain boundaries on that regulatory authority. For the founders, the kind of quintessential boundary is self-interested, corrupt legislation. For the Republicans, in the 1860s, the quintessential boundary is the Black Codes, race-based discrimination in civil rights. And for the most part, what the 14th Amendment is doing is recognizing that Congress or federal judges could step in when those boundaries are exceeded. It's not, in my view, saying anything that would undercut the authority of states to regulate rights in promotion of the public good. So you might have differential treatment of property rights, liberty rights generally, maybe even speech rights across state lines, at least insofar as there's not specification of what speech rights entail through customary law. But there are going to be also boundaries on the state's authority to regulate, and those are the boundaries that the judges at the federal level are supposed to step in and enforce.
If there's time for one more question, I have a question about the drafting of the Bill of Rights. And to what extent did the founders think of that as being a codification of customary law, or was it a codification of natural rights, or was it some synthesis of the two? And I know how you would argue for customary law at that time.
Yeah.
But how would you argue for natural rights if that was an element of the drafting of the Bill of Rights?
Yeah, so I think that the simplest answer is it's both, that it's a jumbled blend of references to both natural rights and customary rights. You can see this most clearly in the First Amendment, which includes references to things that are obviously customary rights, the right to petition being in particular the clearest example. The freedom of the press entails at least a rule against prior restraints, which is a right supplied by customary law dating back to the late 17th century. But then those rights are also easily identified. Other rights in the First Amendment, press, speech, and religion, easily identified as natural rights. And so it could easily be the case that when the founders are drafting those provisions, they're thinking both in terms of customary rights and natural rights. I want to hedge a little bit because getting back to the point about the Ninth Amendment, there's very little reason to think that it would matter whether you locate a right as a First Amendment right or as a Ninth Amendment right, because the drafters are recognizing that the codification of the right or the enumeration of the right is not changing the right's fundamentality or existence. Whether we classify that right, whether we say the First Amendment is recognizing customary rights and the Ninth Amendment is recognizing natural rights, or vice versa, I don't think it matters much. And so we don't see much debate on that at the outset. James Madison, in his June 8th speech of 1789, when he's introducing the Bill of Rights, mentions that it includes both natural rights and positive rights, but it's not followed up by any discussion that would give us a broader sense of how people are thinking about this. But I think it's right to say it's a mix of the two, and that even if it isn't a mix of the two, it probably doesn't matter because of the Ninth Amendment. Thanks.
Well, we have run out of time. That was a fascinating talk, Judd, and please join me in thanking Judd for that.